agree to the decisions of each other, and we have a number of interesting propositions coming up. Some of the important decisions which are going to be discussed, I would take only 3 decisions because I don't think there will be appetite for us now. This is the last session anyway. And Saturday we have started the session at 8:30 in the morning, and we are going to be ending at 7 o'clock in the evening today, and that too on Saturday. The 3 decisions which possibly will take care of the decision, or 3 or 4. One is the payment for softwares. This payment for software, shrink wrap or otherwise, question arises is what is the status? We have the position, Supreme Court decided in a particular manner, then we have the amendment to the domestic law retrospectively, saying that from 1/7/76, all the payments for software will be a royalty. After the decisions, after the retrospective decisions, we have got decisions from the tribunal saying that, well, in certain situation, it is not a royalty. So we have a decision of a Nokia Network OI, the Finland company having presence in India for creating the telecommunication network. And in the process of that, the permanent establishment was created, and then they imported software. The head office supplied the software for the generic software for use of that company in India. They imported that. The payment was made for use of those software. Question arises is it a royalty? And if it is so, whether in India the question is, whenever you say something is in the nature of a royalty or a fees for technical services, and the amounts are paid to a non-resident, of course for resident as well there is withholding tax now. And if the payments are made to a non-resident, you must withhold the tax. And if you do not withhold the tax, then straightway all the payments are absolutely disallowed as an expenditure. They are not allowable deductible expenditure. So therefore consequences are significant, and if you take a view that yes, we want to withhold the tax, the domestic law says withholding tax is 10%. Normally the non-resident recipient does not agree to obtain the tax registration number in India, the permanent account number so to say. And if you do not obtain the permanent account number in India, the consequences are again double. Withholding tax under the domestic law is 10%, it becomes 20%. I think Gokul Chaudhary, if you can throw light on this subject so that it will be interesting. Let us see what debate we can make out of this.
Certainly, TP. I think this judgment sort of follows the decision that we earlier had on Ericsson, and we've also had simultaneously these amendments carried out in the Finance Act of 2012, which have a retrospective effect. And I think usefully this decision just does bring out the fact that whether or not these are retrospective, you cannot read these changes into the DTA, the double tax agreement, and we are very fortunate that we have over 80 treaties which are there, and most of them are similarly worded and distinguished from how the domestic law is worded. So really the Finance Act does carry out changes which tries to explicitly bring to tax the software transactions. But that's a domestic law. The treaties still stand, and the treaties don't stand amended, and I think that's very useful. And I think, what we will have here is a unique sort of situation that while we do look at whether the constitutional validity of these retrospective amendments, do they stand or they do not stand, because these are certainly not changes that are clarificatory in nature. They are certainly a new taxing jurisdiction being established by way of the change in law. Also, the changes that they are proposed with the retrospective effect, they don't really align to the Copyright Act. So really we have an issue that the tax laws are sort of disregarding what are rights that are considered to be rights under the Copyright Act here. And then, of course, I think somewhere the treaty negotiators will have to have a fairly tight balancing as they deal with treaties going forward. How do they negotiate treaties? Do they negotiate treaties to push them towards what India has retrospectively enacted, which is to try and bring such software transactions to be taxable on a source country basis? And if India does that, is India actually going to be the gainer from this process? Because India is becoming also an exporter, a global exporter of software. So really, are we trying to apply some legacy mindset in a futuristic world where India does want to be a dominant software power? So I think we have 2 or 3 things which are emerging. One is, of course, that I think the position stands reaffirmed that we need to distinguish between a right in a copyright and a copyrighted article. That certainly stands reaffirmed. The treaty position stands reaffirmed, which is very useful. And I think the go-forward position on how treaties are going to be reworked needs to be better understood.
Sunil, do you think that there are Indian position on the tax treaties, various tax treaties which we have? They have in some of the tax treaties position of royalty to be treated as, software also to be treated as a payment of royalties, and most of the tax treaties do not have such a position. Would you like to comment upon that?
Well, actually, this precise point was made before the Delhi Tribunal in the case of a GraceMac Corporation or Microsoft, that where the countries desired that software should be taxed as royalty, then they provided so in the treaty. So in those cases, of course, the treaty is free to tax the software as royalty, but where there is no express provision in the treaty to include software, then the normal rules of interpretation should apply. But the Delhi Tribunal did not agree with that argument and said that the provision may have been inserted purely for the sake of clarity. And even otherwise, on an interpretation, it is possible that payment for software may be covered under royalty.
So also there is a Karnataka High Court took a similar view, but there are the other high courts which do not agree with this proposition. Interestingly, in the Supreme Court of India has taken a view that there is a distinction between copyright and copyrighted product, but that decision was in the context of the excise, the Andhra Pradesh sales tax. But the Indian tax authorities do not agree with that proposition, despite the fact that we in the afternoon heard Mr. Datar that for the McDowell purposes we look into the excise decision, not for the purpose of the software. This one ruling which is going to create quite a tension in the Indian tax situation, because if you look at the law which is amended now, they say even the database subscription also could be treated as a royalty. Now only saving device is, of course, the tax treaty provisions in the context. Would you like to add something, Bijal?
Just 2 more points which I would like to add, in addition to what my other panelists have said. One is that there has been a positive decision with respect to reseller arrangements, where you have a distributor in India, you have imported software, and then on a reseller basis you actually sell that software. Now, interestingly, in a particular case, the tribunal has said that though generally the reseller arrangement would have a particular provision with respect to license, lease, etc., of the particular copyright in that particular software, they've gone on to say that in essence, irrespective of whatever has been provided in that particular agreement, the essence of the agreement is only to make use of that particular data behind the software and not really the IP located in it. So I think one positive decision is with respect to reseller arrangements. And the second would be in the case of, where generally for software, they've taken a view that when you're selling software in itself, not necessarily are you actually selling the copyright in it, and it's only a copyrighted article. So this really follows the de minimis principle as enunciated by the US Treasury rules, in addition to what the OECD has said in the Treasury rules of 1999. That's it.
Shreya, you want to add something to this?
Just one point in addition to what Gokul mentioned about how the amendments don't conform to the Copyright Act understanding of what royalty would be. And I think while under the Income Tax Act, we do have deeming fictions, which create artificial, arrangements in relation to which tax consequences would apply. So, for example, the Income Tax Act definition of transfer is wider than the Transfer of Property Act definition of transfer. One thing which we probably need to think about, especially in the context of deeming fictions like this, is whether it's a good goal for tax policy to try and stick as close to the private law definition of a particular arrangement as possible. So whether that's something that we even need to be aiming for, or whether that's something that we're happy to do without?
Well, the consequences are very interesting. In India, we have not only software which is subjected to withholding tax. If you are an Indian company, there could be a service tax, there could be VAT, value-added tax, all such consequences. This is a business which is, needs to be done with a care and advice from the consultants appropriately.